facial.
Yeah, no.
Yeah.
So maybe
We shouldn't be talking about it.
I couldn't get anything on yet.
All right, well, let's do some.
Walter Hopkins there, I don't know who is Rhonda Randa attorney?
Who?
I don't see, the name after Mr. Hopkins, is that an attorney?
Okay, let me in so I can see. Oh, yeah, that's a lawyer, yeah.
I don't see, oh, here, Genevieve Taylor for Attorney Randa, got it.
Okay.
Okay, so we'll do him first, and I'll try the jail.
Okay, so we're gonna do Hopkins.
Right. And
Okay,
see
you
my
let
note?
me in, and I'll start the video.
Okay, and,
Jazz.
my note on that first one is Tanya appointed Mr. Daniels and Mr. Andrews and Joshua Daniels, but she can't appoint on felony. So we got Romy Mezzi, but he can't call until 9:15.
Okay,
So here, Hopkins.
all right, so who is
Mr.
it?
Hopkins, Mr. Coleman, and
Stephen Mammoth's name is on this thing for Hopkins. Why is that?
who?
Mammoth,
No, on Hopkins it's Randa.
but he's on the file. On all of them. That's what's weird.
There's Mr. Hopkins.
That is really strange.
I don't know.
So why does the file say Hopkins? I mean, why does the file say Mammoth? See? Mammoth.
Well, we'll find out.
Yeah. Oh, he substituted in on September
Oh,
9th.
okay.
Okay, all right. So this is case number 20S00634FD. That's people of the state of Michigan versus Walter Hopkins. And we also have case numbers 20S00163A and B. And these are people of the city of Southfield versus Walter Hopkins. May we have appearances, please, for the record, first for the people?
Good morning, Judge Shannon King, coming appearing on behalf of the people.
All right.
Good morning, Your Honor. Genevieve Taylor appearing on behalf of the attorney of record, Jeffrey Randa, with the consent of Mr. Hopkins. Mr. Hopkins, is that correct?
Yes.
Okay, and let's see, we are here today via Zoom remote video technology, and this is for a probable cause conference on the charge of operating under the influence of intoxicating liquor per se, third offense, which is a felony with a maximum penalty of up to 5 years in prison, and also carries up to 30 days to 1 year in jail, 48 hours to be served consecutively, and a fine of from $500 to $5,000. And it does carry operator license sanctions as well in the form of points, additional suspension of the license, and possible vehicle immobilization. And we have 2 city civil infractions from the city of Southfield: preliminary breath test violation and driving a wrong way in a special zone on a one-way street. Okay, so you understand all of those charges, Mr. Hopkins?
Yes, Your Honor.
Okay, and we were here, not here previously, I don't think. Let me check. I see we have a substitution of counsel with Mr. Randa coming in for Mr. Mammoth, but I don't see where we've been before me. So this is an opportunity, sir. You know you have a right to have a trial or preliminary examination on this charge of third offense, operating while intoxicated, with your lawyer representing you, and that's within 21 days of your arraignment and within 7 days of today's date. You understand that, sir?
Yes, Your Honor.
Okay, and so let's just find out, Ms. Taylor, how would we like to proceed today in this matter?
Thank you so much, Your Honor. My office has requested discovery. I believe it was September 10th through the prosecutor's office. We do not have any discovery yet. We also reached out to the prior attorney. He was supposed to get us some discovery. I believe he had half of what we were looking for, but I have nothing as of yet with respect to discovery. So I would request.
Yeah.
I would request an adjournment If it goes outside the statutory time frame, I'm sure Mr. Hopkins would have no problem waiving his right statutorily. Mr. Hopkins, that just means that you would just waive a time period, not the right to have a preliminary exam. You understand?
Yes,
And that'd just be so we could get discovery. Are you okay with that?
yes,
Okay. So, Your Honor, we would request an adjournment so that we have the opportunity to accurately review that before making any decisions.
All righty, that's not a problem. Um, well, any idea about the discovery? I know there's been a few show causes out there about discovery. What's your take on that, Ms. King Coleman?
Judge, actually, I'm not sure who the request went to. I just found out like just now that Mr. Randall was representing Mr. Hopkins, so I didn't know until just now. So, but I will definitely make sure that I can get the paper discovery out via email. And seeing as though it's a city of Southfield case, it's not an MSP case. Any other discovery should not be a problem. I will also provide the Southfield discovery request form so you can get any in-car as well.
Wonderful. Thank you. I do appreciate that. I think we just sent it to the general office. I think that's what they did. So they didn't try to go through you, Ms. Coleman. So I do apologize for that, but it just notes that it's sent to the prosecuting attorney and then the main address. It was faxed over.
Okay.
And Your Honor, just for procedural, I did talk to the city attorney of Southfield and he agreed to adjourn or do whatever, basically follow the felony case. We have no objection to that as long as the court doesn't.
No, I would have done that anyway. You didn't have to ask him, but it's good that you did, because usually these things just trail along until there can be some kind of resolution at some point. All right, so let's get about a 2-week or so date. It'd take about 2 weeks to get that. Well, Mr. Hopkins, we're gonna go ahead and waive the 21-day rule that your lawyer was talking about. And that's when I told you you had a right to proceed to have your exam within 21 days of your arraignment or within 7 days of today's date. That's gonna be somewhat impossible because your lawyer doesn't have all the information yet. So we're gonna go ahead and waive that, and you certainly don't have a problem doing that. Is that correct?
yes, Your Honor.
All right, and I'll just ask, is anybody forced or threatened you to waive your rights to proceed within the time frame here?
No, Your Honor.
You haven't been promised anything, correct?
No, Your Honor.
Waiving it voluntarily so that you can be prepared, is that correct?
Yes, Your Honor.
So find that the waiver is voluntarily made and for good cause. And our new date will be,
October 8th at 1:30.
and this is for a probable cause conference, October 8th, 2020 at 1:30. And we'll set everything else over to October 8th, 2020 at 1:30, and we'll continue the bond. And let's see what pretrial services says. He's testing at JAMS. He completed his initial test on the 13th of September. It was negative. And they don't have the test after that just yet. So keep doing what you're doing, sir. Looks like you're going along pretty well, okay?
Okay,
All right. Bond is continued. We'll see everybody back in October.
Ms. Taylor, who should I send the discovery to?
You can send it to Mr. Randa's office. It's jrandalaw@gmail.com. And that's RANDA, like panda, but with an R.
Got it. Okay, thank you so much.
Of course, no problem. Thank you. I do appreciate this.
No problem.
Thank you, Your Honor. Have a nice day.
All right, you as well. Take care now.
Next one is Jack Plummer with
With who?
attorney Rebecca Coleman.
Oh,
Yes.
all right. Did you change jazz? Okay.
Good morning.
Good morning.
Good. This is case number 20M00198 SD, People of the State of Michigan versus Jasmine Plummer. Appearance of record for the people.
Good morning, Judge Shannon King Coleman, appearing on behalf of the people.
Good morning, Your Honor. Rebecca Coleman on behalf of Ms. Plummer. And could you state your name, ma'am?
Jasmine Plummer.
All right, and good morning, Ms. Coleman and Ms. Fuller. And we're here via Zoom remote video technology today for a pretrial 1 count of operating while intoxicated, which is a 93-day misdemeanor with up to a $500 fine. And of course, it does have driver's license sanctions in the form of points, additional possible suspension of the license by Secretary of State, and possible vehicle immobilization. So you do understand the charge, Ms. Plummer?
Yes.
Okay, and we were here previously, and we adjourned it so that we could get Ms. Coleman appointed. That was back on August 19th. And so we renoticed it for today. So Ms. Coleman, I see you just got your assignment, let's see, the end of August. So have you had a chance to really get any discovery and talk it over with your client at all yet?
No, I haven't, Your Honor. I was actually going to ask to be placed in a breakout room because the number that I've called from Ms. Plummer has been going straight to voicemail. So I want to check and see if that was the correct one. And I did send her an email yesterday, but I don't know if that was the correct one either because I didn't get a response back yet.
JasminePlummer@gmail.com. Is that right, Ms. Plummer?
Yes, I just didn't check my email yesterday.
Okay, is your phone number still in 7123?
Yes. I haven't got no phone calls.
It's been going straight to voicemail. It doesn't even ring, but I can give you my number. I'll send you that.
Okay.
All right, yes, because I don't know what's going on with the phones. But Mrs. King Coleman, does she have discovery yet?
No, Your Honor, she does not, but I will make sure that she gets discovery in the next few days.
All right, so we're gonna have to adjourn this for Ms. Coleman to get some discovery. And you have Coleman's email, you're gonna email it to her?
I will email it to you. Can I get a good email address for you, please?
Yes. It's Rebecca. I'll send it to you right now in the chat if that'll work better.
Okay, that's fine. Can you also put your P number in there too, please? Thank you.
No problem.
Date for another pretrial on
October 30th at 8:30.
October 30th at 8:30 for another pretrial. Is that good, Ms. Coleman?
Say that date one more time, Your Honor.
October 30th, the day before Halloween at 8:30.
Works for me, Your Honor.
Okay, good. All right, Ms. Plummer, so you're gonna call back in on Zoom, and that will be October the 30th at 8:30. We'll send out notices, and
Okay.
you're on for today. Okay, so take care.
Ms. Plummer,
Okay.
get my phone number.
Yes, I got it.
Okay, thank you.
You're welcome.
All right,
All right, have a good day.
you as well. Okay.
Okay, I got successfully just not jail. We
And who is,
Maya Oliver.
she's in jail?
And we have the attorney down. So,
Maya Oliver, pretrial, and the attorney is who?
Donald Andrews,
Oh,
he just got appointed.
right.
And
Change jams. Case number, this is number 20S00190ST, People of the State of Michigan versus Maya Oliver. Appearance for the record for the people.
Good morning, Judge Shannon King Coleman, appearing on behalf of the people.
All right.
Good morning, Your
Mr.
Honor. May I
Andrews.
please- I'm sorry.
Yeah, go ahead.
Good morning. May it please the court, Donald Andrews, on behalf of Miss Oliver, who looks like she is here by Zoom.
Yes, she is. And Miss Oliver, tell us what your name is.
Yes, Maya Oliver.
All right, Ms. Oliver, you are here today via Zoom remote video technology, and this is for a pretrial. You have one count of operating while license suspended, second or subsequent offense, which makes it a 1 year maximum penalty misdemeanor with up to $1,000 in fines, and it does carry driver's license sanctions in the form of points, possible additional suspension of the license by Secretary of State, and possible vehicle immobilization. You have a count 2, operating while intoxicated with an occupant less than 16 years of age in the vehicle. So that's a maximum penalty misdemeanor of up to 1 year in the county jail, a fine from $200 to $1,000. And also it carries the same type of driver's license sanctions as the driving while license suspended charge. So you understand both of your charges?
Yes.
You certainly have a right again to trial on these charges by a judge or by a jury with Mr. Andrews representing you. You understand that?
Yes.
Okay. So, Mr. Andrews, I think you were recently appointed. Have you had a chance to get any discovery from the prosecutor in this matter?
Your Honor, I was appointed yesterday afternoon. I did get all the materials, but I have not had a chance to speak with Miss Oliver yet or get the corresponding police reports. I did talk with her, somebody at her home, I guess, a Marcus, who explained to me that she has some other matters, possibly at circuit court, but I looked on the record and I don't see anything outstanding, so I need to really speak with her.
Sure.
So I guess I'd be asking for adjournment, if I could get discovery and speak with Miss Oliver.
Yeah, that's no problem. Is there some car video or something that he needs to get, which would take a couple of weeks, I guess? Okay, so let's do that, at least a couple of weeks for Mr. Andrews here.
9:15.
Your Honor, is it possible to do the 9th? That's 3 weeks. I think that would give us time to get any video.
I'll check.
I got October 21st at 1:30.
Well, it moved from what? What was the first one?
Oh, the 21st?
No, what?
The first one was October 23rd, I just moved to 21st, but I didn't hear the details.
It go.
I don't really have it. First, October.
Looks like October's kind of booked. First date we have is
October 21st at 1:30.
October 21st at 1:30.
That's fine with me, Your Honor.
She has what? Does she have those? We don't know, right? That's what we're saying. We're not sure.
Some information I've got says she has a hold in circuit court, but I've looked up her record and I don't see anything. I guess she's raising her hand. Maybe Ms. Oliver can tell us just on that issue. Ms. Oliver, don't talk about the case, this case. Just tell us what your status is.
Yeah, it's on the front of the file.
Yeah,
So, okay, October 21st at 1:30 then?
yeah. So October 21st at 1, we've got next day. And the file will continue, and that will be for another pretrial via Zoom. So. And we'll also have an iPad. All right, so thank you very much. We'll see you all back in October.
Hold on, Mr. Tell
Wait.
Mr. Daniels to hold on a minute.
Mr. Daniels, who's that?
I mean, Mr. Andrews.
Oh, all right, Mr.
I'm here for
Andrews.
Mr. Daniels also.
Shelia, right, known as Daniels. She said if you could hold on just a minute. All right, so if we can let
No
Miss
problem.
Oliver go. All right, so Miss Oliver, we'll see you back in October. All right,
I'll contact you, Ms. Oliver.
okay.
Mr. Daniels.
His name is Mr. Andrews.
I mean, Mr.
You keep saying
Andrews.
Daniels.
You were mistakenly appointed to Mr. Daniels from the MIDC Southfield, attorney list. It's a felony, so circuit court had to appoint somebody, so you're not on that case after all.
Did you
That's
know
what I
that?
thought. Yeah, I talked to the MIDC attorney yesterday that says he's out, and she said that it just came to her, so I showed up today just so there's no confusion. That's fine.
Yeah, that was
He does have, it looks like he does have a felony. I did talk to him, so
Oh, you did talk to him, huh? Okay.
yes. He, is that attorney here today?
Going in.
I don't know.
No, Romy hasn't called in yet. It's Romy Mendez.
Oh, it's Romy Mezzi, and he has not called in just yet.
He
apparently.
just got it, he's gonna.
He just got it, so he's gonna call a little late.
Okay.
So we'll explain to
I think
Mr.
I think he's gonna need more time, Judge. He's gonna need, to set this out so that he can put something.
He might very well.
That's fine. If he has an attorney, as long as he's covered.
Yes, he's covered. So thanks so much, Mr. Andrews. All right.
All right.
Have a great morning, Judge. Thank you, Ms. Coleman.
Yeah, you
Thank you. Have a good day.
I have Bonjay Johnson, Judge.
I don't know who he's
Still
with.
waiting.
Does he have a lawyer?
No, I'm still waiting for Romy.
Who?
Still waiting for Romy, so.
Is he on Mr. Johnson?
Bonjay Johnson. No, Bonjay doesn't have an attorney.
Okay. Well, I'm trying to see where his file
Did you
is.
let him in?
I did.
Oh.
But where's the file?
It should be in there, I checked them all.
Ah, here it is. It's got, why do these all have different?
Oh, some come from Kristen, some come from.
Okay.
Oh, here we go. Director review.
Did you start?
Yeah, we need your little sign, Judge.
Okay.
Oh, we've got a video that you. Right.
You still looking?
Oh, Mr. Daniels, Mr. Andrews. Okay.
Let's see.
We
We can
got
get
it.
him
We
in.
still don't have a count.
Cannot hear you. He said he knows. The vibe is probably not here, is she?
No.
That's Marla Osborne.
No, I don't see her.
Who's Christopher Stuckey on?
Yeah, that's exam. Toussaint's not in there, that's not till
Oh,
9:45.
yeah.
Here's a phone number, maybe he's calling back on his phone number, should we let him in?
Let's see who the phone is.
It might be him.
Hello.
Hi, who is this on the phone, please?
This is Terrence Sewell.
Mr. Sewell?
Yes, ma'am.
Okay, Mr. Sewell, all right. You don't have the ability to call in with the video?
No, ma'am. I'm on a landline.
Oh, okay, all right. So, Mr. Sewell, we just wanted to know who you were.
Okay.
And now we know. And we'll
Okay.
have to put you back. Not quite ready for you, but it'll be just a few minutes.
Okay, thank you.
That's Mr.
Let
Sewell.
me rename him.
Yeah.
Terrence.
Okay, so can we put him back?
Yeah. I don't see the other guy.
Yeah, I thought he called back.
We lost him. Oh, Shannon.
Well, he's here. Let's tell Mr. Dan, I'm gonna send him a message.
Got a Jason. Wonder if Jason's sitting in for Ronnie. I don't know who Jason is. See a Jason in there? We don't have a Jason.
Okay, I sent him a letter.
Can we see what Jason is? It could be someone sitting in for Ronnie, because
I
Ronnie.
don't know, let's see.
Who Jason is? I'm turning this.
I'm gonna go back to Mr. Sewell in a
Oh,
minute.
I brought in this Jason.
I did too.
We're doing the same one. All right. Okay.
All right, let's find out.
There he is.
All right,
There he is. You should know.
hello, can you hear me, sir?
Yes, ma'am.
Hi. Okay, sir, you're on.
Christopher Stuckey.
Okay, so you're here for the exam.
Yes.
Okay, and what's your full name?
Jared Jason Weebeck.
How'd you spell the last name?
Wiebeck.
Yeah, please.
I know I didn't.
She said, could you just repeat the spelling again?
Wiebeck.
That, so change his name so we know who he is, and he's on, Stuckey. All right, we're still waiting for counsel on that matter. Mr. Stuckey is here, so we'll put you back in the waiting room, and hopefully it won't be too much longer. It's not till 9:45.
No problem. I was told to, get in early and make sure everything was working.
Right. All righty.
Bring him back. Okay, now who you want?
Okay, let's go with Mr. Sewell then, since Mr., who is Shantae's Galaxy?
That's.
Oh, Shantae Jones, that's what
Right,
Mr.
but messy too.
Okay, so let's go back to Mr. Sewell. So where did Mr. Sewell's file go? Terrence Sewell.
Yes, ma'am. I called from home.
Okay, we're back with you, Mr. Sewell. All right, we're gonna call your case, just a moment.
Okay.
All right, this is case number 20OS08452AST. This is people of the state of Michigan versus Terrence Sewell. Appearance by the prosecution, please.
Good morning, Judge Shannon King Coleman, appearing on behalf of the people.
All right, good morning. And now, Mr. Sewell, tell us your name for the record.
My name is Terrence Sewell.
And Mr. Sewell, we are here today via Zoom remote video technology, and you're on the audio telephone portion because you do not have video. And this is for a pre-trial. And the charge is the violation of the financial responsibility law. And that is a 90-day misdemeanor with up to a $500 fine. And you certainly have a right to have a lawyer to represent you at a pretrial or trial. And if you couldn't afford a lawyer, I would appoint one for you. And let's see. Looks like we have the prosecutor here today, and I don't know if she's in a position to offer you something. I'll find out from her. And then if she does, ask you then, what is it that you'd like to do? Would you like to take the offer or have a lawyer? Okay, so Ms. King Coleman?
Judge, I have not had an opportunity to review this matter at all. I don't know what ticket it is, and I haven't had an opportunity to review Mr. Sewell's driving record either.
All right, well, the ticket sir, hold on, because since we're on this remote technology, it's hard to hear when two people talk. All right, so the ticket is from March the 10th, and it was on Chapel and 8 Mile Road for operating while suspended for failure to prove financial responsibility. All right, and let's see. If you're looking for a driving record, it's kind of thick, but it looks like, as I'm turning through the pages, looks like he had a lot of suspensions and things, but they look like most of them are terminated.
Yes, ma'am. I paid all of them off, and I went down to 36th District Court, bonded myself out, and made a court date for October 2nd for the last 3. And I just went a week before and took care of one of the most recent tickets. And I went and paid at the what is it, kiosk. I went and I've paid all of my tickets I had at 36th District Court, like you were asking for, and I've got a court date for October 2nd for the last 3, and I've paid like $300 for to bond myself out.
All right, because I see, everything looks taken care of except for he's got. Well, sir, I'm trying to tell the prosecutor.
Oh, okay.
So, because she does not have what I have, which is your driving record. So let me tell her what I see. I see on a 2019 December 4th, failure to appear in court out of Detroit on license not valid or improper license, which went into suspension March 26th of this year. And he also has from January 15th of 2020, failure to appear in court on a no insurance under the insurance code. That went into suspension on April the 9th. He had another matter out of that same January 15th instance, but he paid that. That was a registration plate violation. So it looks like he only has 2 matters in Detroit, and he says that he just got a court date for those. So that's all I see.
Okay, in light of that, Judge, if people move to dismiss the original charge and add an amended count of allowing an unlicensed driver to drive.
Okay, so Mr. Sewell, prosecution here is going to dismiss the original charge and add a count of allowing an unlicensed driver to drive the motor vehicle, and because it's a misdemeanor, it carries 90 days and a $500 fine. The difference is because the charge is allowing someone else to drive without a license, it does not go on your driving record as a driving conviction. It does go on your criminal record as a criminal conviction, but you don't get any points in any other driving sanctions because of it. So that's the good news.
Okay.
So would you like to take advantage of that? We would dismiss the original charge, and you could plead to this charge if you like, or if you want to talk to us, I would appoint one for you.
No, I'd like to accept that charge.
Okay, so we're gonna have to go over the constitutional rights that you would have had at a trial that you're getting ready to give up because you're pleading. If you understand these rights, all you need to do is say yes as we go over them together. All right?
Okay.
So we're gonna start with the fact that, again, you know you have a right to trial with a lawyer, and the trial could be by judge or by jury, but you're giving that up. You understand that?
Yes, ma'am.
And at that trial, you also would have a right to subpoena witnesses. And that means you have a right to ask the court to order any persons that you'd like to come forth to testify for you. And you're giving that up. You understand that?
Yes, ma'am.
Okay, in a trial, you also have the right to question through a lawyer any witness that's brought against you by the prosecution. You understand that?
Yes, ma'am.
Right to testify on your own behalf at trial, but if you chose not to, that fact could not be held against you. You understand that?
Yes, ma'am.
And of course, you have the right to be presumed innocent unless you're proven guilty beyond a reasonable doubt by the prosecution. You understand?
Yes, ma'am.
If you're on probation or parole status and you're pleading guilty today, the plea could be considered a violation of probation or parole. You understand that?
Yes, ma'am.
And we do have an advice of rights form, but you're unable to see it because you didn't call, you called in rather than are on video. So it essentially is all of the rights that I just told you here on the record.
Yes, ma'am.
And just a second. I think the only other thing on this form that I didn't tell you is the fact that you could appeal within 21 days from the date of your sentence as permitted by the court rules. And the sentence, if it involves incarceration, and if you wish to file an appeal, but you can't hire a lawyer, then the court would appoint a lawyer for you on appeal if you make a request within 14 days. Other than that, pretty much the rights on the form are the same rights that we've just gone over. Do you have any questions?
No, ma'am.
All right, understand that if I do accept your plea today, that you will not have a trial of any kind, and you will be giving up those rights that I went over with you that are listed on that form that we talked about.
Yes, ma'am.
Also understand the possible penalties on this charge of allowing an unlicensed driver to drive is 90 days and $500 fine. That's the maximum.
Yes, ma'am.
And you still wish to plead guilty to allowing an unlicensed driver to drive.
Yes, ma'am.
Anybody force or threaten you?
No, ma'am.
Been promised anything other than the plea agreement itself?
No, ma'am.
You're pleading freely, voluntarily?
Yes, ma'am.
Hey, Mr. Sewell, is it true that this offense occurred on March 10th, 2020, when you operated an Acura motor vehicle upon Chapel Street near 8 Mile Road, which are highways open to vehicles in the city of Southfield?
Yes, ma'am.
And you wish to plead guilty to allowing an unlicensed driver to operate your motor vehicle as well on that date and location. Is that correct?
Yes, ma'am.
All right, people satisfied?
Satisfied, Judge.
All right, then I'm satisfied with the facts that support the plea and that the plea is freely, understandably, voluntarily, accurately, and knowingly made. So therefore, I am going to accept the plea and dismiss the original count of violation of the financial responsibility law pursuant to this agreement. Okay, so anything else you want to let us know before we pass the sentence here, Mr. Sewell?
No, ma'am.
All right, so, yeah, go ahead and make sure that you, I don't know why you let all your tickets get to suspension first. Why don't you just take care of them when you get them?
I'm not for sure, ma'am.
You don't know why you don't? Okay, you know it costs you way more money when you do it this way.
Yes, ma'am.
Because what happens is you'll end up getting an extra interest accrues and penalties, fees also accrue on your ticket. And then you got the reinstatement fee. So you end up paying a lot more money if you could just take care of them early on. But at least you do take care of them, so, which is good. All right. So I'm gonna assess a fine here, $230, a $75 crime victims' rights fee pursuant to statute. Let's see. And I don't think there's a statement here, so you should be good. Let me make sure that I have proper information, because the criminal division will send you a notice about your fines and costs, okay? So are you
Okay.
still on Grand in Detroit?
Yes, ma'am. And
And your phone number still is the same? I think it ends in 3841, is that correct?
Yes, 531-3841.
Okay. And did you have an email?
No, ma'am. No, not at this time. I don't know.
Okay. All right, so at least we know how to contact you, and I don't see that you posted a cash bond here, so you will need to pay this. And how much time would you think you need?
Maybe about a month now.
Okay, so we'll
Probably
give
less
you
than that.
October the 19th,
Okay.
that's about 30 days.
Okay, that's good.
They'll send a notice out to you about how much, okay? You're all set, thank you.
And how much do I owe? You said 230 plus 75.
Yeah, there's a $75 crime victims fee. I don't believe that there's any statement fees on this, so that should probably be it. If it's something I missed, they will send it to you.
Can I go to the not the Kinko, to like at 36th District Court, or do
Okay,
where
let
what?
me give you let me give you the number to the criminal division. They can tell you all kind of ways that you can pay, okay?
Oh, okay, okay,
And
okay.
you can walk it in here, because we're open to take payments and to conduct business, but they close at 3 o'clock. So,
Oh,
but I'll
okay.
give you their, okay, their number
Okay.
is 248-796-5880.
Okay.
All right?
Okay. Okay.
All right, take care now.
Okay. Thank you.
Yes, bye-bye. Okay, now we've got,
Mel, I just left a message for Romy, because he's got Daniel and Joe.
hold on, Marla Osborne.
She's not in there, so you can do it.
Okay, let's do Osborne.
Well, Roman just sent us an email saying that he's tied up in Zoom hearings at the 36th Court and Frank Murphy, and he should be calling in by 10 or 10:15.
Okay, I'll send a message.
Okay, and in the meantime, while you're doing that, we'll call the Marla Osborne matter. This is case number 20SO00383ASM, People of the State of Michigan versus Marla Osborne. This matter is scheduled today via Zoom remote video technology for a probation violation hearing at 9:15. The defendant has failed to appear via Zoom, and it is now 9:50 a.m. Let's see, looks like this might have been an in-person hearing. And so since she has failed to appear in person today, court will issue a bench warrant. And we'll set a bond. Looks like, oh, well, let's not issue a bench warrant. Probation says she never appeared for her probation appointment, and this is from January of this year. But it looks like, based upon the test driving record, that the defendant is deceased. And here's an obituary indicating that she passed away April 21st, 2020. It's from a funeral home. All right, so no bench warrant. Because she's deceased, gonna waive any balance of fines and costs. And will terminate the probation, close the case.
We want to try Untitled Johnson, see if he has some microphone.
I talked to him once, didn't I? No.
Yeah, but he needs a microphone. I'll bring him back. It's all right. Here we go.
Do you hear me now?
Yeah,
Okay.
this is case number M3691144ASI, People of the State of Michigan versus Barney Johnson, appearance by the prosecution.
Good morning, Judge Shannon King, coming appearing on behalf of the people.
And your name, sir, for the record.
Von J. Johnson.
Mr. Johnson, you are here today via Zoom remote video technology, and this is for a formal hearing on a civil infraction for operating too fast or too slow for conditions. And let's see. I don't know if the prosecutor has had a chance to review your record yet, but we'll find out from her if she's able to offer any type of resolution. Looks like we were here July 8th. All right. And at that time, Ms. King Coleman, you indicated, well, I indicated at least, that the original ticket was to be dismissed because it was under the wrong MCL code. Oh, and so this was the rewrite. Okay.
Correct.
And the defendant did not have notice of it. The attorney on the other case was Michael Leonardo's. So we reset it to a September date. And we asked the clerk to call and see if Mr. Leonardo's was still going to be representing the defendant on this rewrite. So let me ask you that, Mr. Johnson. Have you had touch with Mr. Leonardo's? Is he still representing you?
I've talked to him, but no, he's not representing me.
Okay. All right, so then we can move forward. Any offers?
Yes, Judge, I have had an opportunity to speak with the trooper on this case, Trooper Wickham, and the offer today is to dismiss the original count and add an amended count of impeding traffic.
All right, sir, they're offering you impeding traffic. Impeding traffic is also a civil infraction. It does carry a fine. However, it does not go on your driving record. So there's no points involved in it, and we don't put it on the driving record. And it just carries a fine. And if you'd like to take advantage of that offer, then we could dismiss the too fast or too slow for conditions, which does go on your driving record. And it does carry 2 points as well. So that would be dismissed. Is that what you like to do?
Yes.
All right. So, is it true that this offense occurred January 15th, 2020, at around 4:05 a.m. when you were operating a Chevrolet vehicle on eastbound I-696 freeway near Inkster Road and Franklin Road, which are highways open to vehicles in the city of Southfield?
Yes.
On that particular date, you wish to plead responsible to impeding traffic. Is that correct?
Yes.
All right, I'll plead to impeding traffic and dismiss the too fast or too slow for condition. All right, impeding traffic's fine is $160. Do you have that, now or what?
Not right now. Is there a way that you could like give me 30 days from today to pay the fine?
Yeah. I can.
Okay, please.
Let's give it to you. Don't forget, because it'll go into suspension if you forget.
Okay.
That'll be Monday, October 19th.
Okay.
Is your phone, what's your phone number, Mr. Johnson?
248-996-4321.
Okay, and you're still on North Park Drive?
Yes.
Okay, and do you have
I didn't hear.
any email? Do you have an email?
Oh, it's vonj81@gmail.com.
All right. That gives us a few ways to contact you. Someone will probably send you a notice about the ticket and when it needs to be paid, okay?
Okay.
All right, and we are open, so you can walk in your payment, but they close at 3 o'clock. Close a little early.
Okay.
All right, so you're all set. Take care.
All right. Thanks. Bye.
Mr. Mezzi was in there, but now he hung up again, so you wanna just see if the exam's going?
Oh, okay.
Yeah, Mr. Mezzi was there, he hung up, so I don't know if he is.
I don't know what he's doing. I got time to worry about
See
it.
the exam if it's going.
Yeah, I'm gonna let Mr. Tucson in.
Mr. Stuckey.
Because you know what, we can always stop it and handle
Right,
one
handle
thing.
that one,
Okay.
yeah.
Got it, Jan?
Mhm.
Okay. This is case number 20H00544FT.
No, we got Stuckey.
Oh, I'm sorry. Wrong case. Hold on. There we go. All right, this is case number 20S00357FY. People of the state of Michigan versus Christopher Stuckey.
Good morning, Judge
Here's what-
Shannon King Coleman appearing on behalf of the people.
And good morning, Your Honor. May it please this most honorable court, Vincent J. Tucson on behalf of Christopher Stuckey.
All right, and Mr. Stuckey, your name?
No idea. Send him a message.
Oh, boy. Okay, hold on.
You share your screen if you got my message.
Hello?
All right, sir, what is your name?
Hello.
Hello, what is your name, please?
Christopher Stuckey.
All right, Mr. Stuckey, you are here today via Zoom remote video technology, and this is for a preliminary examination on account of felonious assault or assault with a dangerous weapon, which is a 4-year felony with a $2,000 fine. And it looks like we also have this set for a bond violation hearing, emergency motion to revoke bond as well. All right, so, we going to exam today? Ms. King Coleman?
The people are ready to proceed, Judge. Is Officer Boone in your waiting room from the Southfield PD?
Officer who? I got Weebeck.
I need Jared Weebeck, and then there should be an Officer Boone. He was in to be here as well.
No, he's not there.
Okay. The people are ready to proceed, but before we do, can you put me and Mr. Toussaint in a breakout room? Is that possible?
Sure.
Thank you.
All right, put Toussaint and King Coleman in the room.
They're going. She just said, ask, if it comes to me, we have help.
It's a notice that they can.
Yeah, she can write and chat with me, and we have help.
You have somebody in here?
You probably did. Yeah, they're registered. I just use my paper. Just using my paper, my last one in here too.
I'll bring that other one in here. Probably needed more in here than I did in the room.
Okay.
Cause you can always use the one from my office for your office. Did you go on the other table too?
Nobody was open there.
Oh, really?
Guess it won't hurt. I'm hoping our maintenance people.
They say they come in and do that spray.
They spray some kind of stuff, but they only do it like once a month.
That, yeah. But that's because we haven't had a whole lot of people. I think they'll do it more regularly if we ask.
Yeah, once we start having more people. Okay, here, she just asked for help.
he went out.
Right.
All right, so we're back on the record here with the Stuckey exam. So are you now ready to proceed?
Ready to proceed, Judge.
And on behalf of Mrs. Stuckey, we are so ready to proceed, Your Honor.
All right.
So, Judge,
So-
can I ask you this procedurally? Do you want me to take testimony from the witness regarding the bond motion as well while he is testifying regarding the exam? Are you going to handle it separately?
Separate, just so we can keep it clean, so that I don't confuse the facts for the exam with the facts for the bond. Because how many witnesses do you actually have other than him? I only see him here.
Yeah, I just texted Detective Rada. I confirmed with him that Officer Boone was going to be present to testify today. I just texted him asking him where he was. I haven't received a response yet. But the people I'm ready to proceed with just Mr. Wybeck. So
All
just
right, well, so I think the way to do it would then, we'll question him about the incident, give Mr. Toussaint an opportunity to cross-examine. Then if there's no other witness here, we'll just then go back and ask him about the incident after the incident, the alleged bond incident. Okay.
Can we take Mr. Gann from as he now is a pre-exam?
You know what? All right, hold on just a moment. We have counsel here that we've been waiting for on a real short matter. So we're gonna put you guys back in the waiting room for a couple of seconds, Mr. Toussaint and your client. Hold on, let me change it to who?
We're gonna do Romy Daniels and
Romy Daniels.
Joshua Daniels and Romy Messi. Boy, I'm using Daniels for everything. That was the very first one, so we're waiting for this. There we go.
Good morning, Your Honor.
Good morning.
I'm back.
This is case number 20H00544FT. People of the State of Michigan versus Joshua Daniels. Appearance for the people.
Good morning, Judge Shannon King, coming appearing on behalf of the people.
Good morning, Your Honor. Romy Messi, 68245 on behalf of Mr. Daniels. Your Honor, I was just appointed this morning.
Let me get your client name on here. What's,
Sure.
sir? Are you still looking for your sound? Okay, hold on just a second. I'll share my note with them. As soon as we see him, to see if they know how to do
Well,
what
we
they're
brought
doing.
him. He had the first time.
Oh, he was
Yeah,
already
it
on the
was,
record?
yeah. He said I'm back, so I don't know how to know.
That was wrong. Okay, Mr. Daniels, can you hear me now?
Yes, I can.
Okay, tell us what your name is for the record.
Joshua Daniels.
All right, and so Mr. Daniels, we're here today for a probable cause conference, and we're via Zoom, remote video technology this morning. The charges here is possessing 2 or more forged driver's licenses or counterfeit licenses. The maximum penalty is 5 years in prison and a $10,000 fine, so that's the felony charge. You also have a misdemeanor operating while licensed. Second offense, 1 year and $1,000. And it also carries driver's license sanctions as well in the form of points, suspension, license, and possible vehicle immobilization. So you are the 2 charges, correct?
Yes, ma'am.
right, to have a preliminary examination on that felony charge in 21 days of your arraignment and within 7 days of today's date. You understand that?
Can you repeat that? I'm sorry.
I said you have a right to have a full preliminary examination, a full hearing on the felony charge to test the sufficiency of the evidence. And you can have that within 21 days of your arraignment and within 7 days of today. You understand?
Yes.
Okay, so Mr. Mezzi, you were saying earlier,
Your Honor, I have not had an opportunity to confer with my client. I was just appointed to represent him.
okay,
As it is, I've got no discovery at this point. I'm going to ask the court to adjourn this matter out for another probable cause conference with Mr. Daniels' permission, knowing that he is not waiving any right to his preliminary examination hearing. Do you understand that, Mr. Daniels?
Yes.
Okay. And after reviewing the discovery with Mr. Daniels, at that point, we will make a decision whether to hold this preliminary examination hearing or not. Do you understand that, Mr. Daniels?
Yes, sir.
Okay. I'd ask to proceed that way, Your Honor.
okay, and we can do that. Mr. Daniels, do you mind the 21 day rule? Because you still needs to get the police report and any other information to get so that you can discuss it with, decide how to proceed. So it's be a little bit longer than probably 21 days or 7 days from this date. So do you mind waiving that right?
Okay.
Yeah, so has anyone threatened you or forced you to waive this right?
No.
And have you been promised anything to waive it?
No.
And you're doing so voluntarily because you need information to discuss with your lawyer. Is that correct?
Yes.
All right, so I'm gonna find the 21-day waivers is freely understandably voluntarily and knowingly made due to the need to have some discovery. And we'll set this out for another probable cause conference via Zoom,
October 3:45.
October the 8th at 5,
At what time, Your Honor?
3:45. Is that good, Mr. Mezzi?
That's good. 3:45 p.m. That's good.
3:45.
Yes, in the afternoon.
Okay,
We're gonna send
that works.
send a notice out. All right, bond is continued, except for, yeah, in this matter, bond is continued, yeah,
Thank you, Your Honor.
okay. All right,
I will call you, Mr. Daniels.
Okay.
Okay.
All right.
Shantae Jones, before he hangs up, Judge.
okay, well, what about it?
She was in there earlier, now she's gone.
Shantae Jones was your other client? She
Yes,
was in
Your
there
Honor.
early, but now she's gone?
Yeah, she was in there. So I
What
don't know.
was it for?
It was a delayed
Delayed.
sentence.
Yeah,
Your Honor, if I can go on mute, I can try to call her and see what happened with it.
it was a first offender program. Yeah.
Right.
Not a delayed sentence.
Can I try to call her?
Sure.
Okay.
She was on that gallery.
There she is.
Got her back? Oh, there
She's
she is.
here.
Okay, here she comes. Shantae Jones. All things are started. Everything's going.
Is that her? Ms. Jones, can you hear us? No.
Can you hear me now?
Yes, thank you very much.
You're welcome.
Let's rename her. Let's say. Yeah. All right, this this is case number 20S00008 SM for the state of Michigan versus Shantae Jones. Appearance for the record for the people.
Good morning, Judge Fanning, can come in appearing on behalf of the people.
Good morning, Your Honor. Romy Meskin on behalf of Ms. Jones, who is present by Zoom.
And your name, ma'am?
Shantae Jones.
And Ms. Jones, you're here via Zoom remote video technology, and this is for a sentencing apparently. I don't know why they says it's a review. It's really a review under the first offender program of the sentence that the court imposed on one count of disorderly person, drunk in public. And there's a report here saying that the defendant has not fully paid. She's been on this probation for 6 months, a little over 6 months.
I did pay.
Ma'am, hold on.
Okay.
If you let me finish, it'll be a lot quicker. Because you can't go back and forth because we're on this Zoom and it's hard to hear. So we'll let you say in just a minute.
Okay.
It looks like probation since January 15th, and she appeared for hearing July 22nd. She needed time to pay, so we adjourned the hearing over to today. She still owes $165 is what I have here, and that's what the receipt and the file shows. So do you have $165 to finish paying off?
I went in the court building this morning and I finished paying it.
Oh, okay. So we would not have that receipt yet because the file's up here. So let's pull it up and see. It should be on the computer, hopefully. Okay, she's all paid up. And the suggestion is for her to take the status under the first offender program. So I need some forms, which I don't have any forms from the prosecutor.
Okay, I thought that we submitted the forms when we were there in person.
I need dismissal of her case.
All right, I'll submit the dismissal.
Yeah, we have everything else, but we don't have the operative form, which is she has earned that right to have her case dismissed under the terms. So we'll make a note as of today's date.
So for the record, the people moved to dismiss the charge because the defendant had successfully completed the Oakland County Prosecutor's Office First Offenders Program, and I will give an order of dismissal to the court within the next week.
No objection, Your Honor.
Well, I guess not. So Ms. Jones, congratulations on successfully completing everything. This is really what this program is all about, is to give people that may have made a little lapse of judgment, got themselves involved in the system, a second chance so that they can move forward, not have the stigma of any kind of convictions on their record. So you certainly earned that. Anything you want to say?
I just want to say thank you. I have truly learned my lesson, and I would never be back in trouble ever again.
Well, I will.
That's my passed away. So, you know, my dad never wanted me to be in trouble or be in any kind of thing. So I just wanted to say thank you guys. I appreciate it. And this will give me a chance to be able to finally, when they open the border, to see my kids.
Oh, absolutely, because they really won't let you across the borders with convictions. They're real strict about it now, especially with COVID. Yeah. I hope cross. All right. So
yes, they haven't opened it yet, ma'am, and I can't wait till they open it.
Well, congratulations again, and move forward to do good things. Okay. So we'll get the order signed from the prosecutor, and we'll get that out in the mail to your lawyer, and then you can get a copy from him. Okay.
Okay. Will he give me a call to give me the copy?
I will. I'll call her also.
She says he'll call you. All right.
Okay, so it would be off my record. It won't be on there.
That's right. As soon as I can get the form from the prosecutor, we get it signed, it'll be gone.
Okay, thank you so much.
Take care, Ms.
All
Jones.
right.
You
Good
too.
luck.
Thank you. Okay. Bye-bye.
Okay.
Thank you, Your Honor. Do I have anything else or am I done?
No, I think you're all set.
I'm all set. Have a great weekend. You too, Ms. King Coleman.
You too, Mr. Merkel.
Take care. Be safe.
Hey. So let me find the dismissal first. Okay. All right, you back on the record with them too? All right, well, so, okay, we're back on the record now with 20S00357FY, people of the state of Michigan versus Christopher Stuckey for preliminary examination. All right, we took a brief recess in order to handle a couple of short items. And so now we're ready for the exam here. And so, Ms. King Coleman, is there any other preliminary matter that we need to address?
Nothing from the people judge.
And from the defense?
Your Honor, just a motion to sequester any and all witnesses who will be testifying in this matter.
All right, and so I think we only have one, but is that true or not? Because if so, and we have more than one, we'll go off the live feed and that will sequester it.
Well, has Mr. Officer Boone called in?
No.
So it will just be one witness, Judge.
Do you think he's going to be calling in? Did you have some contact? Because I'll go off the live feed if he is.
Okay, I have a text message out to Detective Ryder, who has not responded at this point, but did confirm that Officer Boone was notified of the hearing and that he would be present today.
All right, well, we'll go off the live feed just in case. And for anyone that wants to watch this exam, we will post the exam later after we finish everything. We'll upload it out to YouTube, so it could be available for the public. But we have to go off the live feed in case there's witnesses that are also watching the live feed and listening to what the other witnesses are saying. Okay, all right. So we're off the live feed right now. All right, so call your first witness.
The people called Jared Weebeck.
All right, Mr. Weebeck will be coming in momentarily. Jason, is Jared Jason?
Yeah. Hello.
All right, sir?
Yep.
What is your name?
Jared Weebeck.
All right, and raise your right hand to take an oath, sir. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, and can you please spell your name for the record?
Yes. Jared. Jason, Jason. Weebeck, Wiebeck.
Okay, and so correct the spelling of his name, please. Jared, please. Okay, Ms. King Coleman, whenever you're ready.
Good morning, Mr. Weebeck.
Good morning.
Let me first ask you, do you have any documents in front of you?
Do I have any documents in front of me?
Right.
I got the instructions for the Zoom meeting.
do you have anything else, a police report or statement or anything like that?
Not directly in front of me, no.
Thank you. Can you please state your name for the record?
My name is Jared.
And I'd like to draw your attention to April 14th, 2020. What were you doing that day?
I was working in my apartment,
And where's your apartment located?
Southfield, Michigan, on Franklin Road,
What's the name of your apartment?
Regal Towers.
Okay. And what floor do you live on in that apartment?
First floor.
How long have you lived there?
I've lived in the apartment for 10 years, but this particular apartment for 7. I was up on the 5th floor previously.
And you said you were working that day. And did anything unusual occur while you were working?
Yes, somewhere around 5-ish, well, a little bit before 5. I heard, I'm sorry?
AM or PM?
PM.
Okay, go
A little
ahead.
bit before 5 p.m. I heard some very excessively loud music playing from the parking lot outside my apartment. It was so loud that my windows in my apartment were vibrating.
Okay. And when you heard that loud music, what did you do?
I made the decision on whether or not to call security or go out and find out who was playing the music really loud. And so then I proceeded to go out and, because it was the middle of the day, you know, go out and find out who was playing the music and see if they would turn the music down.
Did you call security as well at that point?
No, I didn't call security until after the incident where Mr. Stuckey pulled the knife on me.
Okay. And so you made the decision to go investigate, see where the music was coming from. What happened next?
I stood out there. Mr. Stuckey in his car, sitting there, drinking a beer, smoking looked like a cigar type tobacco product, singing to the music.
And how do you know this person, Mr. Stuckey?
I don't know him at all. The only reason I know his name now is from the incident.
Okay, so you didn't know his name before?
No, I had no clue, nor had ever seen him.
So can you just tell us, describe what you observed when you went outside to the parking lot?
So I went out, I saw him sitting in his car. I saw him with his eyes closed singing the music. And I stood there about 3 to 4 feet from his car and waited for him to look up and see me standing there.
Were his windows up, or were the windows on the vehicle up or down?
They were up.
What kind of vehicle was it?
Like a crossover type vehicle.
Okay. And the person you saw in the vehicle, do you see that person in the proceedings today?
I see myself, I see Judge, I see, well, hold on, yes, I do see him now.
Okay. And can you please describe an article of clothing that he's wearing right now?
He's wearing a white button-down shirt. It looks like he's got a beard and a mustache.
Okay, Your Honor, let the record reflect the identification of the defendant in these proceedings.
So ordered.
Thank you. Had you ever seen Mr. Stuckey before that day?
No.
Okay. And so when you went out to the parking lot, what happened after that?
I stood there. He finally looked up at me. He rolled his eyes, closed his eyes, went back to singing for a bit. A few seconds, maybe 20, 30 seconds. Then he looked back up again at me. He rolled the window down and said, "What the fuck do you want?" At that point, I said, hey man, I live right here on the first floor. I'm just asking you to turn your music down. He goes, I live here too. And he told me to shut the fuck up. And he said, I was trying to oppress him. And then he broke out his cell phone and tried to start filming it. I felt that he was trying to turn it into something like a racial incident because he was saying that I was trying to press him and he was trying to get it on.
Objection as to what he's what he's speculating the Mr. Stuckey is thinking.
Yeah, sustained. All right, sir, just tell us what you know, not what you think he meant. Okay, so go ahead. What's the next question?
Are you talking to me or?
No.
Prosecutor needs to ask a question to stop the narrative. We don't want it to be a full narrative. So go ahead and ask questions.
Okay. And so how far away from the vehicle were you at this point?
Roughly 4 feet, 3 to 4 feet away.
Okay. And so what happened after he asked, what the fuck do you want? What happened after that?
I told him I wanted him to turn the music down. I said, hey, can you turn the music down? I'm trying to work. And he said, nobody's working at 5 o'clock or whatever, this late in the day. And I said, I am. And he was insulting to me. And I told him that he doesn't know how to spell oppression.
So when you said he was insulting, what do you mean by that?
Telling me to fuck off and saying other stuff like that.
And what happened next?
Then he reached over into the passenger seat of his vehicle and grabbed a folding knife.
So can you describe the knife that you saw?
It was kind of like a shiny metallic knife that kind of had like a rainbow feature, where you changes color depending on what direction the light is hitting it at. And it had a blade of approximately 3 to 5 inches.
So you said it was a folding knife. When you saw it, was it folded or unfolded?
When he pulled it out, it was unfolded. He unfolded the knife.
So you saw him unfold the knife?
Yes.
Okay. And where were you at this point when you first saw the knife?
I was standing in the same place that I was, which was about 3 to 4 feet away from his car on the driver's side.
And was the window down still at this point?
No, he went from the window down he had opened up the car door at that point.
So at the time when you saw the knife, the car door was open?
Yes.
And Mr. Stuckey opened the door?
Yes.
Okay. And did he make any movements toward you at this point?
Up until that point, he kind of like turned towards me, still sitting in the car, but he was turned facing me a little bit.
Did he have the knife in his hand at that point?
Yeah.
Did he say anything when he pulled the knife out?
Yeah, he said, get the fuck away from me or I'm going to fuck you up. And then he got out of the car and took 2 steps towards me and said, you better, I'm going to fuck you up. And I said, at that point in time, when he got out of the car, I'd already backed up a few more feet. So I was probably about 6 to 7 feet away from him. And then I said, listen, man, I'm calling the cops on you. And I backed up till I felt I was a safe enough distance away, and then turned around and walked into my apartment. And then I proceeded to call the police. And then I called the apartment security at that point.
Okay, so did he make any gestures with the knife at all?
He held it in front of him, pointed at me at about somewhere between his belly button and his chest.
And was the blade unfolded or folded at that time?
Yes, it was unfolded.
And so you said you took some steps back. Why did you take those steps back?
Make sure that there was distance between us, to the point where if I needed to, turn and run, that I could do so without having him be able to close that distance real quick.
So were you afraid that he was gonna cut you with the knife?
Cut me, stab me, harm me in some fashion with the knife, yes.
And you testified that defendant said that he was gonna, quote, fuck you up. What do you think he meant by that?
I felt that he was meant to cause great bodily harm to me in some fashion or another.
And did he say anything else to you?
Did he say anything else?
Yes.
After he threatened me?
Yes.
No.
Okay. Did he say anything else besides he was gonna fuck you up?
No.
Okay.
Not at that point. When he was outside of his vehicle and he had the knife in front of me, so I'm gonna fuck you up. That was it. You know, I turned around and, you know, started, you know, going back into my apartment.
Okay. And what did you do when you went back into your apartment?
Like I said before, I immediately got on my phone and called the police and called security.
And did the police arrive?
Yes. I think security got up there before the police did. And then the police got here.
The Southfield Police Department?
Yeah.
Okay. And did you go back outside when the police arrived?
Did I go back outside? Not right away. I was in the hallway talking to the police. And that was it. I didn't go outside of the building.
Did you give a statement to the police?
Yes.
Okay. And do you have any knowledge of whether Mr. Stuckey was arrested on that day?
I believe he was. I also told the police that they should grab his camera on his phone.
Hold on 1 second, just answer the question. And your apartment is located in the city of Southfield?
Yes, ma'am.
In Oakland County?
Yep.
Okay. I have no further questions at this time, Judge.
All right, cross-examination.
I can't hear. He's muted.
Mr. Webeck, can you hear me now?
I sure can.
All right, thank you. You indicated that during the time that you lived in the apartment, you never known Mr. Stuckey, have you not?
That's correct.
You didn't even know his name until the police report was made, am I correct?
That's correct.
You indicated that on the date in question that you walked out to the vehicle where Mr. Stuckey was seated, am I right?
Correct.
What did you have on?
Shorts and a t-shirt, sandals, I believe.
Did you have your hands in your pockets?
No.
When you indicated you were about 3 to 4 feet from the door, am I correct?
Yes.
And how tall are you, Mr. Webeck?
About 5'7".
You said he was sitting in a crossover type vehicle. Is it a tall vehicle or is it kind of a shorter vehicle?
Shorter crossover.
So you were able to see in the interior of the vehicle?
Yes.
Did you ever touch the vehicle at all?
Not in any way, shape, or form.
Because you were still about 4 feet away, am I correct?
Correct.
And you were 4 feet away at all times, am I right?
I never was closer than 4 feet away.
And you indicated you even backed up further to about 5 to 6 or 7 feet away, am I right?
That statement's not exactly. It's kind of hard to answer that question the way you phrased it.
Let me rephrase that question. You indicated that when Mr. Stuckey came out of the vehicle, you backed up even further, am I right?
That is correct. After he came out of the vehicle, I backed away even further.
Indicated that Mr. Stuckey had the knife at what part of his body?
Well, when he first pulled the knife out, it was, you know, he was sitting in the car, so it was, you know, right in front of his chest. And then when he got out of the vehicle, it was somewhere between his chest and his belly button, mid torso, would say.
So when you see him actually, you saw him actually grab the knife from the passenger seat, am I correct?
I did.
The knife was closed at that time, am I right?
He unfolded it. He grabbed it, he picked it up, it was, then it unfolded it.
When you see him unfolded, do you back away even further from the vehicle?
I took a few steps back.
So when he opens the door, you're not in any distance from the door when he opens it, am I
He
right?
opened it before he pulled the knife.
Okay. So he opens the door and then he pulls the knife out?
Correct.
The knife is open at this time?
He opens the door, then he pulls the knife and opened it. The knife.
When he opens up the knife at this time, is the knife pointed up, down, or where's the knife pointed toward?
He would have had it in his right hand. And at that point in time, when he turned towards me, it was kind of in my general direction.
But I'm asking you, where was the knife blade pointing? Is it pointing
In my
towards the
general
ground?
direction.
I'm not asking you your general direction, Mr. Webeck. I'm asking you a direct question. Is it pointed up? If you know, if you don't know, Mr. Webeck, you can say, hey, I can't remember, or I don't know. But if you can remember, Mr. Webeck, tell me whether or not the knife blade was pointed up, down, or towards the ground, or do you know?
I don't, the way you're answering the question is not exactly an accurate portrayal of.
You can't ask me a question, Mr. Webeck. I'm asking you
I'm not
a simple
asking you.
question. You're not what?
I'm saying that he turned in the car to the point where he was facing my direction with the knife in my direction.
I'm asking you a simple question, Mr. Webeck. Is the blade of the knife pointed towards the ground? Is it pointed up? Is it pointed towards you, or do you know?
Yes, it was pointed towards me, which is what I just said. He pointed it in my general direction towards me.
Okay. So the blade is pointed towards you?
Yes.
That's what I need to know. And at this point in time, you're about, what, 7 feet away? 6, 7 feet away?
About 5 to 6 feet away.
Okay. He doesn't lunge towards you, does he?
No, he didn't lunge.
Does he run towards you to stab you?
No.
Does he swing the knife at you?
No.
Do you know what happens with the knife, Mr. Webeck, before you turn and walk back into the apartment?
Do I know what happened to it? No.
Yes. Thank you, Mr. Webeck. I have no further questions.
Any follow-up questions, Ms. King Coleman?
Yes, just briefly. Mr. Webeck, when the defendant got out of the car, did he make any movements toward you at all?
Yes, he took several steps towards me and said he was going to fuck me up.
And what did you do in response to him taking steps toward you?
Backed up.
And had you not backed up, how close would he have been to you when he took those steps toward you?
If I hadn't backed up, he would have been within 3 feet from me.
Okay. And approximately how tall is the defendant relative to how tall you are?
I think he's close to 6 foot.
Okay.
Give or take a couple of inches.
I have no further questions, Judge.
All right, that'll conclude this, witness testimony on this issue. Let me see. I think that's your only witness.
Okay, Judge.
As far as this part of the exam is concerned, are you, resting at
The
this
people
point?
rest, Judge. I have no further witness.
Mr. Toussaint, did you have any witnesses for the exam?
Your Honor, we have no witnesses at the exam. We rest as well.
Okay, and so for purposes of the, bind over, did you want to make a motion and argument?
Yes, Judge. The people have proven by Mr. Webeck's testimony that by a probable cause standard that a felonious assault occurred and that this defendant committed the felonious assault. And the people moved court to bind the defendant over as charged. And I reserve any argument for rebuttal.
Okay, Mr. Toussaint, any argument?
Your Honor, based upon the testimony of Mr. Webeck, I think what we have is a brandishing of a weapon. Mr. Webeck was never in distance of being stabbed or being, there was no swinging motion of the knife. There's nothing that would indicate that Mr. Stuckey was going to use this knife. Asking Mr. Webeck, there is a brandishing of the knife to show Mr. Webeck can, get the bug back, but there was, I would indicate, Your Honor, even at this probable cause standard, the prosecution has failed to show a felonious assault, and they have shown a brandishing of.
Well, let me ask you a question. If we just had him sitting in the car, opening a knife, maybe. What do I do with the fact that he turns towards Mr. Webeck, pointing the knife, then gets out of the car, pointing the knife, he says, between his middle torso at him, walks towards him, and then says, I'm gonna fuck you up. That's showing no possible intent that he meant to maybe use the knife or injure Mr. Webeck. It wouldn't cause a reasonable person to fear or apprehend a battery.
I'll defer to the court.
Okay. Did you want to, Ms. King Coleman?
Judge, it sounds like the issue is that the defendant had the ability to commit a battery and appeared to have the ability, as indicated, the defendant took the knife, opened the knife, made these threats, opened the car door, took steps towards Mr. Webeck, but Mr. Webeck had to step back to protect himself or out of fear of apprehension that he would be stabbed. So Judge, the people do believe that the elements have been met by a probable cause standard and ask that the court find the defendant over.
All right, well, the court agrees with the prosecution on this argument because we don't have to prove this matter beyond a reasonable doubt, Mr. Stuckey. This is not a trial. This is a probable cause hearing. And so the people have to provide evidence on each element of the crime, not whether or not it was accurate, but do they have enough where a reasonable jury could possibly find guilt. And so the elements of this crime of felonious assault or assault with a dangerous weapon are that the defendant either attempted to commit a battery on Mr. Webeck or did an act that would cause a reasonable person to fear or apprehend an immediate battery. And a battery is a forceful or violent touching of a person or something closely connected with the person. So the first element is, was an act done that would cause a reasonable person to fear an immediate battery? And the evidence was that a knife was grabbed out of the vehicle while sitting in the vehicle. It was flipped open. You turn towards Mr. Webeck, pointed a knife at him and said to him, as you opened the door and got out of the car, and pointed it at him, get out of my way or I'm gonna fuck you up, basically, or something to that extent. That is an act that a reasonable trier of fact could conclude that would put a person in the reasonable apprehension or fear of a battery. The next element of the crime is that the defendant intended to injure Mr. Weebeck or to make him fear immediate battery. Well, I don't understand why the words would be spoken, I'm gonna fuck you up, if there was no question that there was some kind of possible intent to injure. The words themselves give the impression that there is an intent to injure. Third element is, at the time, the defendant had the ability to commit the battery. I don't think there's any question that there was an ability, because there was a knife in hand and the defendant was about 4 feet from Mr. Weebeck and started to approach him closer, and the testimony was that if he hadn't backed up, he would have been within 3 feet of him. So there was an ability to either commit the battery or there was the thought that the defendant had the ability to commit the battery. Can be inferred from that whole scenario. The last element is that the assault was committed with a dangerous weapon. The testimony was that the defendant had a folding knife, and a knife in and of itself can be considered to be a dangerous weapon, especially when used or purported to be used in that manner. And in this manner, the weapon may not have been dangerous at first when it was folded up, but certainly once it was opened up and a threat was arguably made, certainly that fits the definition of dangerous weapon, which is any object. It doesn't even have to be a knife, but any object used in a way that is likely to cause serious physical injury or death. And Mr. Weebeck testified that he believed that if he didn't move, that there would be some kind of serious physical injury, or he used the words great bodily harm to me in some manner. So based upon the totality of the testimony, the court believes that people have proven each of the elements of the crime of felonious assault or assault with a dangerous weapon by a probable cause standard, and that the matter should be bound over for a jury to consider whether or not this has been proven beyond a reasonable doubt. All right, and so now we will move forward to the bond argument, as the court will bind this matter over as charged here in the complaint and warrant.
Thank you, Judge.
All right, so the bond motion is a motion for bond based upon the fact that there was an allegation, at least in the brief, that says that Mr. Stuckey just could not stay away from Mr. Weebeck during the course of the pendency of this matter. And I can take judicial notice of my file that the defendant had a $15,000 personal bond with some conditions, and the conditions were pretrial services supervision, have no contact with Mr. Weebeck, do not assault, harass, or intimidate him, beat him, molest him, wound, or threaten him, or any other witnesses. Don't go to 27200 Franklin Road, number 107A. Do not possess any weapons or firearms. So that was the bond condition. And your motion apparently states that apparently on August 29th, there was some kind of incident that occurred over there, and Mr. Weebeck apparently, and I'll let you all back this up, but the motion says Mr. Weebeck was sitting in his apartment and smelled smoke, looked out to the hallway, found a smoldering cigarette in the carpet, went to security, talked to somebody who then looked into it with the camera system, and supposedly it showed the defendant intentionally putting a lit cigarette outside of Mr. Weebeck's door, which caused the smoldering and the burning. which arguably is a violation of the pretrial release by even going close to the apartment. So that's your argument, Ms. King Coleman?
Correct.
Mr. Toussaint, you want some testimony on this?
Your Honor, there is a video. Ms. Coleman showed it to me. King Coleman showed it to me today. I think she plays it for the court. Video speaks for itself.
All right, well, so, Ms. King Coleman, did you want to play the video, need to play the video? It seems like the defense is kind of capitulating that there is a video, that it does show Mr. Stuckey flicking the cigarette over outside of the witness's apartment, contrary to the order not to even go over on that floor.
No, Judge, I don't see a need unless the court wants to see the video. If Mr. Toussaint is stipulating. Yeah.
Your Honor, I think the court can view the video. I think it's probably important for everyone here, Mr. Webeck and Mr. Stuckey, to actually see this video.
All right, who has the video?
I do.
All right, you're gonna share your screen with us?
Yeah.
Okay.
There are two videos, actually.
Okay.
One moment. Can the screen be seen?
Yep.
Yes, Your Honor.
Mr. Webeck, you live here. Can you describe, do you want any testimony or do you want me to play the video, Judge?
I'd like to just see the video.
I'm talking to the judge.
Oh,
It's up to you. Like, it's your bond motion. I would take testimony since you got a video, yeah.
Mr. Webeck, can you describe what we're seeing here?
you're seeing the hallway right outside my apartment facing, if you look down the camera, down the hallway, that's the lobby at the opposite end of from where the camera is. The side door is right behind where the camera is. And there is an apartment just to the left of where that exit sign is that you see at the top of on the ceiling. Actually, there's one right below where the apartment, right below the camera. So my apartment is the direct focus of like this video camera.
Okay.
On the left or right?
On the left, it's.
Okay, so it's the one that's across from a door that has a mat in front of it?
Correct, Your Honor.
And what is your apartment number?
107.
And on what date did this incident occur?
8/29. I believe it was a Saturday.
So August 29, 2020?
Yep.
About what time?
Oh, roughly 7 o'clock
PM or AM, sir?
PM.
Judge, do I need to replay that back? Did you see anything?
Yeah, no, you need to replay it.
Do you see that light spot that just fell to the floor? Do you see that?
Yes, yes, I do. Looked like it rolled right up to the door.
It was about 3 to 4 inches from my door.
Yeah.
I'm gonna fast forward just a couple of minutes to 27:25.
Man, this is all.
Mr. Webeck, what are we viewing right now?
Reviewing me finding that cigarette out there. Previously, my girlfriend had put her head out the hall and saw that there was a smoldering cigarette. So I opened up the door and I saw the cigarette, and it was still moist with saliva.
What?
And then right after this, I walked outside and threw it outside the apartment complex.
What happened to cause you or your girlfriend to open the door?
Smelled a smell of burning, and I didn't know where it was coming from. So we searched the entire apartment. I couldn't find any source of heat or electrical burning in my apartment, so I asked her to poke her head out in the hall and see if maybe like somebody was smoking in the hallway or a neighbor's apartment was having an issue. And then that's when she found the cigarette. And then that's when I came out, and as you saw there, I picked up the cigarette from the ground.
I'd like to ask one question. Was the carpet burning in any way, shape, or form?
There was only about an inch of cigarette that had been smoldering in there. So it wasn't smoldering for very long. And there was a small little burn test in the carpet.
Judge, I have one other video to play from a different view.
Okay, go ahead.
As you can see from the timestamp, Judge, on this video, it's the same day. This is on a different floor, however. And this is the individual wearing the same clothes, talking in the same manner, same ponytail, same facial hair as we observed flicking the cigarette.
Yeah, okay, that looks like the defendant.
That's it, Judge.
Okay. Did you have any questions, witness, Mr. Toussaint?
I just have a few questions. Mr. Webeck, do you know which floor Mr. Stuckey stays on?
He never told me what floor he's on.
Okay. When you walk into the building, do you have to pass by your apartment to get to other floors in the building?
Not in any way, shape, or form.
So going through the first floor, it would only be for first floor residents?
No, there's down by the lobby, there's a common area where the mailboxes are. And
And let me stop you there. Are the mailboxes for everyone in the building or just everyone on the first floor?
everyone in the building.
Are the elevators in the building as well to take you up to other floors in the building?
Yes, right by the mailbox.
Okay, and that's all on the first floor as well?
Yep. Plus there's a stairwell right next to the elevators. There's absolutely zero reason for him to go by my apartment.
Let me ask you this, is there a stairwell outside of the apartments themselves so you can go outside and not even come into the building?
Like a fire escape? Is that what you're asking?
Okay, no, I'm just asking, is there any other, there's no, you have to come into the building to go upstairs, am I correct?
Yeah, you have to come to the building, but you don't have to come onto the floor. So right outside the first view where the camera was,
yes,
where you saw me picking up the cigarette and him throwing the cigarette down, right behind that is a stairwell. It goes up to the 6th floor, 7th floor, 5th floor. Every floor is accessible from there. So he can go into that door, go up the stairs without having to go by my apartment.
Okay, well, I want to know. Thank you.
Can I say something, Vince?
I wouldn't suggest you say a word, but if you want to talk to your lawyer about that, you want him to say something, you can.
Okay, I wanted to address the whole video, how he came in apparently after I threw a receipt down or whatever it was. That was not no lit cigarette. I ain't wasn't even smoking in the building, first of all. Second of all, whatever came out my pocket, it wasn't directed towards his house. He came in after, looked down and said it was a fire. He kept saying it was a fire and it was smoking, and he sent his girl outside. When he came outside and looked, none of his story is matching up.
None of your stories seem to be matching up either.
Ma'am, there's no way I will go. I'm sorry. I apologize, Your Honor. I
would say do not say anything else, Mr. Stuckey.
Yes, sir.
Let him keep talking.
No,
I apologize.
Because what this video was not a receipt. It wasn't a paper. It didn't drop like a paper, which would kind of float. It went down and it rolled.
It wasn't a lit cigarette.
Well, first of all, we're missing the whole point here. You weren't supposed to be on that floor at all. To even, if you weren't on that floor, there would be no issue with a cigarette, piece of paper, or nothing.
Ma'am,
you weren't supposed to be.
The only reason I was on that floor is because in our building we having technical problems with our key fobs. These notices has been up on the building for a month now. I couldn't get in by any way but that door. You'll see I've been getting in that door all week, all month. If you look at all the cameras, that's the door that's been open. That's the door that let people in. I had company and we was going up the elevator. That's the only reason I came in that door. The front door won't let me in.
Judge, on Zoom, you cannot, unfortunately, tell your client what to do and can't do because, unfortunately, on Zoom, everyone has their say.
I'm sorry.
I would indicate to Mr. Stuckey, do not say anything else.
Mr. Weebeck, what do you know about the key fob system in the building?
I use all the doors. So behind where the lobby is, on the same side of the building where my apartment complex is, there's the trash bins. I've used my fob on that. I use my fob on the front door. I use my fob on the door that I go in. You know, he and I basically would go in and out of the same door, which is the side door behind the video camera. He's got no reason to come by my apartment. If he needs to go get his mail, all he has to do is walk down the hall, the stairwell, by the elevator, or go take the elevator down to the first floor and get his mail and go back up that way. There's absolutely zero need for him to walk in front of my apartment.
Judge, whether the key fob was working or not working, we all saw that there was a lit object that left Mr. Stuckey and rolled toward Mr. Webeck's door. Just a few minutes later, you saw another party walk by and noticed it on the ground. That person didn't say anything. Mr. Webeck testified that he and his girlfriend were in the apartment at the time, smelled smoke. Just a couple of minutes later, opened the door and there was a lit cigarette. Nobody else threw anything or dropped anything by the door. The only person that walked by the door was Mr. Stuckey. The testimony is consistent. It's a direct violation of his bond not to harass, contact, or go to Mr. Webeck's door. Therefore, Your Honor, we ask that the court find that defendant has violated his bond, and at a minimum, we ask that you increase the bond or revoke the bond, but I leave it to the court's discretion, but this is a clear violation of the bond condition.
Okay, Mr. Toussaint, what would you like to say?
Your Honor, I don't think that you should revoke the bond. I think right now, if this court were to place a teller on Mr. Stuckey, that you could possibly know where Mr. Stuckey is at all times and where he's at all times. It does seem to indicate in the apartment complex itself, there is a viable video system, and Mr. Webeck's floor is being videoed. Mr. Webeck's door is being videoed. Mr. Stuckey understands that he cannot go by his apartment, even though if he's in the same building. We have a problem here that both of the individuals live in the same building. Mr. Stuckey should not be going by Mr. Webeck's apartment at any point. So I would request, Your Honor, that don't revoke the bond, and if you want, place a teller upon Mr. Stuckey.
Judge, I would also add that Mr. Stuckey's actions were not only a danger to Mr. Webeck, but a danger for everybody who was in that building. Because had Mr. Webeck not been at home and the cigarette would have caught fire, who knows what kind of flammable things are in the carpet. But if Mr. Webeck would not have been home, the entire apartment building could have potentially burned down. So Mr. Stuckey's actions were a danger to the public as well.
I agree with that. No question about it. This whole case is petty. The whole case is petty. And now we see the actions after the case are equally as petty. This was a simple situation that just got out of control for no reason. Loud, bumping music is offensive to people. And it's no harm to ask somebody, can you please turn it down? Everybody knows people are working from home. So it's not an unreasonable request. So we got this situation that just kind of escalated to something that it didn't have to be with a knife. Okay? You would think that would be enough. But now we have this situation. Mr. Stuckey, you make your own situation worse. The court told you not to go near his apartment. There's no reason to have walked down that hall. Your key fob worked or didn't work. What difference does it make? You came in that door, why didn't you go straight up the steps that were right behind that exit sign and not walk past his apartment? Could have gone straight up the steps to the second floor, walked down the second floor and down if you needed to go to the lobby. There's no reason to walk by there. And from what Mr. Webeck says, the key fob system was working. So you could have gone through the front door. And if you had to go through that door, you sure could have gone in a different direction. And apparently there were steps down there by the lobby. The elevators were working. There's no allegation the elevators weren't working. So it would have been very easy to get from a higher floor down to the first floor to get to your mailbox or anything else you needed to do in the building without going by his apartment. And then to add insult to injury, see, nobody would have probably even realized that you had walked by the apartment had you not dropped the lit object, which you say was not a lit object, which it doesn't appear that that's accurate. It was a lit cigarette that you casually dropped as you went. And I'm not understanding what the point of that was. to try to start a fire, hurt this gentleman more because he said something to you about some noise and you didn't like it? You obviously didn't like it because you pulled a knife. But now, since he called the police, you want to set the whole building on fire. Not endanger him, but yourself and your apartment is in the same building. And any children and anybody else, older people who can't get out of their apartment quick enough, all of these people were at risk because of this behavior. And what for? What do you get out of this? It makes no sense. I can't condone this. Your story doesn't make any good sense to me whatsoever. That it was a piece of paper, it wasn't lit. We watched the video. It was no major length of time here. You dropped the cigarette or the lit object, and within a few minutes, someone saw it, looked down, kept walking, and then another person, Mr. Stuckey, smells it burning. It's that's how people die in house fires all the time. They are smoking the lit cigarette, which people think is not a big deal, is a big deal because it catches carpeting and everything on fire. And the next thing you know, you got a 3-alarm, 4-alarm, 5-alarm fire, and people are dying. Not to mention the property destruction for no good reason. So the court can't condone this kind of activity. It's a violation of our court order. And the court, you leave me no choice in this matter but to do something about this. You know, I'm not going to snatch your bond and remand you to the custody, but I'm going to increase the bond and I'm going to put a tether on you to make sure that you do not walk past this apartment. So the new bond conditions are as such. Yes, there's going to be pretrial services, supervision. Yes, we're going to continue the order not to have any contact with Mr. Jared Webeck. You're not to go to the address in question, which is it 27200, Mr. Webeck?
Yep,
Franklin Road,
apartment 107.
number 107. Do not walk past the door. Possess no other firearms or weapons. You are not to harass, and this is a form of harassment in my view. This whole cigarette situation is harassment and intimidation. If you do any more harassment, intimidating, any assaulting, beating, molesting, wounding, or threatening of any kind of Mr. Webeck or any other witness in this matter, then your bond's going to get snatched. And I'm going to write that in there. Any other violations going by Webeck's apartment will result in revocation of bond. And that will be up to the circuit judge, but that is my note and my opinion on the matter, which I'm certain they will take into consideration. You are also going to have a GPS tether. Now, go nowhere except stay home, I shall say, except work, verifiable doctor appointment, and court if it's necessary to go into court that is not on Zoom. bond is going to be increased. Right now, it's at a $1,500 personal. You can't trust them on personal anymore. So that's gonna be a cash or surety in there. So you need to get a surety to post this. Unless you got $15,000 cash or surety. I'll make it a 10%.
Thank you, Your Honor. And Your Honor, could you include in the visits, the attorney visits as well?
Do you have any people in your office?
Unfortunately, we've had a COVID outbreak at the office, so I've been kind of afraid to go back there, Your Honor. So I think
Aren't you doing Zoom?
I am, but I have to go back in. I'm probably going to end up going back in within the week or so. I think that's when the quarantine is going to be over for the office building.
All right, I'll put verifiable, I thought about it, but I didn't because I didn't think anybody was having people in, but I'll put it in, verifiable attorney visits, which means the tether people, and you must get tethered within 24 hours. So he's gonna have to get it fast. All right, so therefore, if there's any other problems now, Mr. Stuckey, this is an issue. And everybody now is clear on what should and should not be done in that building. Did you have any questions?
No, ma'am.
All right. So the bond is changed to a 10% bond. He needs to get that bond as soon as possible. Else he'll have to turn himself in, Mr. Toussaint. So he needs to be calling some seats today.
I will, Your Honor.
Okay. All right, that'll conclude this matter.
Thank you, Judge.
Thank you very much, Your Honor. Yeah, everyone stay safe.
Thanks, you too, Mr.
Thank you.
Thank you, Mr. Weaver.
Can you end the meeting?